Q107. What do you know about the League of Nations? Describe its functions and its principal organs. Ans. Origin. Although the desire for the establishment of an effective international organization had been expressed long before the First World War, yet it took the real form in the Treaty of Versailles, 1919. By the end of the First World War, the statesmen of the world had finally decided to establish League of Nations. Several drafts were prepared, and finally the American and British proposals were compiled as in a joint draft, known Hurst-Miller draft, which was presented before the League of Nations Commission of the Peace Conference. On 28 April 1919, the Peace Conference accepted the draft, which was given the final shape by the Commission. Thus the Covenant of the League of Nations was adopted. Finally, the League of the Nations was established on 10 January 1920. Functions of the League of Nations. The League of Nations performed the following main functions. I. The reductions of national armaments of the lowest point consistent with national safety. 2. To preserve as against external aggression, the territorial integrity and existing political independence of all members of the League. 3. To settle international dispute peacefully. 4. To bring about peaceful change in international relations. Last, but perhaps the most important function was to maintain international peace and security. Principal organs of the League of Nations. 1. Assembly. All the members of the League of Nations were represented in the Assembly. Each member was entitled to send 3 representatives, but each member state was entitled to have only 1 vote. 2. Council. The principal allied associate powers, America, Britain, France, Italy and Japan, were the permanent members of the Council. Besides this, 4 other members were elected by the League Council. But America never joined it. Consequently, the place of America was filled by a smaller state which was elected by the Assembly. Although the functions of the Assembly and the Council were not clearly demarcated, yet there were certain functions which were exclusively performed by the Council. These functions included the nomination of the additional members in regard to the defense from external aggression and for maintaining territorial integrity of the members. 3. Secretariat. The League of Nations deserves credit for establishing for the first time an international civil service in the real sense of the term. The Secretariat of the League of Nations comprised of 600 officers and subordinate officials. The Secretary General was the Chief Administrative Officer and was appointed by the unanimous decision of the Council. Q108. What were the weaknesses of League of Nations? Mention the factors which were responsible for its dissolution. Ans. Weaknesses and defects of the League of Nations. Following were the main defects and weaknesses of the League of Nations. 1. One of the main defects of the Covenant was that all the decisions of the Council were taken unanimously. This unanimity principle proved to be detrimental for the working of the League of Nations. 2. The Covenant did not completely prohibit war. It simply imposed certain restrictions. 3. Although President Wilson of America contributed much for the establishment of the League of Nations, yet it was unfortunate that America could never become its member. 4. The Covenant provided that if any amendment of the Covenant was not acceptable to any state, then such a state would cease to be the member of the League of Nations. In the course of time, a number of states ceased to be the members of League of Nations due to this provision. 5. The League of Nations also provided for the withdrawal of the members from the League. In the beginning, the League of Nations comprised of 62 members, which in the course of time were reduced to only 32. 6. The Council of League of Nations did not have the capacity to settle the international disputes peacefully. 7. The League of Nations also failed to prevent great powers from attacking and exploiting smaller states. 8. The League was based on the policy of discrimination between great powers and smaller states. 9. Another cause for the failure of the League of Nations was that the great powers always considered their selfish interest over and above all things. 10. Lastly, the League failed miserably to perform its main and primary function of establishing peace in the world. Factors and events leading to the dissolution of the League. In addition to the above defects and weaknesses, certain events which took place also led to the decline and dissolution of the League of Nations. Following are some of the main events in which the League failed to take effective steps. 1. Attack by Italy on an island named Corfu belonging to Greece in 1923. 2. Japan attacked on Manchuria in 1931. 3. Attack of Italy on Ethiopia in 1935. 4. Russian invasion of Finland in 1939. In addition to the above events, the failure of disarmament conference convened under the auspices of the League of Nations in 1932 also proved to be detrimental for the League. The League of Nations proved to be a weak international organization and failed to maintain or establish international peace and security. However, it must be noted that the League of Nations ultimately failed not because of the constitutional defects of its covenant, but because of the members which failed to fulfill the obligations assumed by them under the covenant. Professor Goodspeed has rightly remarked, the League of Nations was abandoned by those who failed to abide by their solemn obligations. The League of Nations was finally dissolved by a resolution of the Assembly in April 1946. Fortunately, due to the untiring efforts of the statesmen of the world, the United Nations was established. It not only took the place of the League of Nations, but proved to be a much more effective and successful organization. Q109 What do you know about the Permanent Court of Arbitration and its composition? Mention some cases decided by Permanent Court of Arbitration. Ans. Origin and nature. By the end of 19th century, arbitration had become popular method of settlement of disputes. The Permanent Court of Arbitration was established by the Hague Convention of 1899. In the Hague Convention, it was also agreed that international disputes should be settled through peaceful means, and decision to establish a permanent court of arbitration was incorporated in Article 22 of the Convention. Composition. The Permanent Court of Arbitration comprises of the following three institutions. I. Panel of experts. 2. Administrative Council and 3. International Bureau. I. Panel of experts. Article 23 of the Hague Convention, 1899 provides, each signatory power shall select 4 persons at the most, of known competency in questions of international law, of the highest moral reputation, and disposed to accept the duties of arbitration. The persons thus selected shall be inscribed as members of the court in a list which shall be notified by the Bureau to the knowledge of the signatory powers. The aggrieved states could select 5 experts from this panel, and thus the temporary arbitration court could be constituted. Some reforms were made under the Hague Convention, 1907. For example, a summary procedure was provided for the settlement of matters of ordinary importance. 2. Administrative Council. It comprises of the diplomatic representatives of the parties to the Convention. It is situated in Hague, Netherlands, and had a small secretariat. 3. International Bureau. The International Bureau is also situated in Hague. It comprises of a General Secretary and certain other employees. Its function is to carry on the administration and keep the records. States who want to use the service of the court for the settlement of disputes are helped by this office through correspondence, etc., and it also serves as a mediator through the states who want to make use of the court. Some important cases decided under the Permanent Court of Arbitration. 1. North Atlantic Fisheries Case, 1910. Under the Peace Treaty of 1783 between the United States of America and United Kingdom, the American citizens had been given some fisheries rights in some part of Labrador, Newfoundland and North Atlantic coast. Formerly these rights were used in collaboration with the British citizens. According to Britain, the said treaty came to an end in consequence of the Treaty of 1812. On the other hand, America contended that the said treaty was only suspended. A treaty relating to American fisheries was also entered into 1818. In 1905, Britain captured certain American fisheries shops. In this connection, there arose a dispute regarding the interpretation of the Treaty of 1818. In 1909, America and Britain had entered into an agreement to refer this dispute to the Permanent Court of Arbitration. The Permanent Court of Arbitration had to decide whether Britain could regulate the rights conferred under the Treaty of 1818 and in case the Britain had these rights, could she exercise these rights without the consent of America? The Permanent Court of Arbitration decided that the right of Great Britain to make regulations without the consent of the United States, as to exercise of the liberty to take fish, in Article 1 of the treaty, is inherent to the sovereign of Great Britain. Further, the exercise of the right by the Great Britain is, however, limited, in that such regulations must be made bona fide and must not be in violation of the treaty. 2. Savarkar's case, 1911. Savarkar was an Indian revolutionary who was being brought to India to be prosecuted. When the ship was in the port of Marseilles, Savarkar escaped. He was later on apprehended by the French naval police. But the captain of the French ship returned Savarkar to the captain of the British ship under the wrong impression that it was his duty to do so. Later on, the French government requested the British government to return Savarkar on the ground that the rules relating to his extradition were not strictly observed. This case was entrusted to the Permanent Court of Arbitration for its award. The Permanent Court of Arbitration in its award made it clear that international law does not impose any obligation to return the criminals after getting them successfully extradited. By this view has been severely criticized in French and Indian circles. It is pointed out that the above rule is not based on the sound principle of justice. 3. Russian indemnity case, 1912. This case was in between Russia and Turkey. Russia had claimed money along with interest and damages as indemnity for Russian citizens and institutions under the Treaty of 1879. Russia and Turkey referred this matter to the Permanent Court of Arbitration. The Court of Arbitration decided the case in favor of Russia. However, the court in its decision made it clear that Turkey was not bound to pay the interest and damages because Russia had waived this right by its conduct. Q. 110. What do you know about Permanent Court of International Justice, its composition and jurisdiction? Explain with cases decided by Court of International Justice. Ans. Origin. The Permanent Court of International Justice was established under Article 14 of the Covenant of the League of Nations in 1921. Article 14 provides that the Council shall formulate and submit to the members of the League for adoption plan for the establishment of a Permanent Court of International Justice. The court shall be competent to hear and determine any dispute of an international character, which the parties thereto submit to it. The court may also give advisory opinion upon any dispute or question referred to it by the Council of Assembly. In pursuance of Article 14, the League Council constituted a committee of eminent jurists and asked to it submit a plan for the establishment of a Permanent Court of International Justice. The said committee submitted a plan, which was approved by the League Assembly and the League Council. Thus the Permanent Court of International Justice was established. Some important cases decided by the Permanent Court of International Justice. 1. SS Wimbledon, PCIJ, 1923, Series A, Number 1. On 21st March 1921, the German authorities stopped a British ship named SS Wimbledon on the ground that it contained military equipments being shipped to Poland, who was at war at that time with Russia. The German authorities contended that allowing the ship to pass through the Kiel Canal would amount to violation of the German neutrality. The prominent Allied nations filed case against Germany in the Permanent Court of International Justice. Deciding in favor of the Allied nations, the World Court held that under Article 380 of the Treaty of Versailles, Germany was bound to allow the passage through Kiel Canal to the SS Wimbledon. The court, therefore, ordered that Germany should pay compensation for violation of its treaty obligations. 2. SS Lotus, PCIJ, 1927, Series A, Number 10. In 1926, in open or high seas, a French mail ship named SS Lotus collided with a Turkish ship named Beyazıt Court. As a consequence of collision, the Turkish ship sunk, resulting in the death of 8 Turkish nationals. After the collision, when SS Lotus reached Constantinople, Mr. Demons, a French national, and the officer on the board were arrested and proceedings were started against them according to the criminal law of Turkey. Mr. Demons argued in the Turkish court that it had no jurisdiction to try him. The court rejected the said contention of Mr. Demons and convicted him. The French government protested against the said act of Turkey and claimed Mr. Demons should be immediately released. The French government claimed that Turkey had no jurisdiction to try and punish Mr. Demons. In its support, France cited Article 15 of the Convention of Lausanne, 1923, and claimed that Turkey had violated the said provision. In order to resolve the dispute, France and Turkey signed a special agreement according to which it was decided to refer the matter to the Permanent Court of International Justice for its decision. The court had to decide whether Turkey violated Article 15 of the Convention of Lausanne, 1923. Article 15 provided the following: subject to the provisions of Article 16, all questions of jurisdiction shall, as between Turkey and other contracting parties, be decided in accordance with the principles of international law. The Permanent Court of International Justice gave its decision in favor of Turkey. The court gave its verdict that by prosecuting and convicting Mr. Demons, Turkey did not violate international law. Q. 111. Difference between Permanent Court of International Justice and Permanent Court of Arbitration. Ans. Permanent Court of International Justice. Permanent Court of Arbitration. 1. Under Article 13 of the Convent of the League of Nations, the members agreed to resolve their disputes through arbitration or judicial settlement. 1. There was no such provision in Article 20 of the Hague Convention 1899, under which the Permanent Court of Arbitration was established. 2. The Permanent Court of International Justice was in fact a permanent institution. 2. The Permanent Court of Arbitration was in fact a panel of experts from which temporary arbitration court could be established. 3. Last but not the least, improvement over the Permanent Court of Arbitration was that the Permanent Court of International Justice could also give advisory opinions. It was a novel thing in the field of international judicial settlement. 3. There was no such provision in the Permanent Court of Arbitration. Q. 112. Discuss the origin, preamble, purposes, principles and membership of United Nations. Ans. Origin. After the First World War, the League of Nations was established, but it failed to prevent the Second World War. The Second World War once again compelled the nations of the world to endeavor to establish an international organization which could prevent future war and maintain peace and security in the world. During the Second World War itself, the great powers had started making efforts in this direction. Their efforts led to the holding of the San Francisco Conference, in which the United Nations Charter was adopted and signed by 51 nations of the world. After the Charter was ratified by the prescribed number of states, it came into force on 24 October 1945. Thus the United Nations was finally established. It may, however, be noted that it was the untiring efforts for a number of years which led to the establishment of the United Nations. The more important factors and efforts which led to the establishment of the United Nations may be briefly mentioned below. 1. The Declaration of St. James Palace, 12th June 1941. 2. The Atlantic Charter, 14th August 1941. 3. The United Nations Declaration, 1st January 1942. 4. Moscow Declaration, 30th October 1943. 5. The Tehran Conference, 1st December 1943. 6. Dumbarton Oaks Conference, 19,441. 7. The Yalta Conference, 11th February 1945. 8. San Francisco Conference, 25th June 1945. Preamble of the United Nations Charter. The preamble indicates that the Charter of the UN is born as a result of the experiences of a devastating war, and that it holds out hope for a lasting peace based on recognition of fundamental human rights which have been the casualties of war, on a recognition of sovereign equality of all states, and on better economic and social conditions for the millions who have been victims of the oppressions and exploitation. We the people of the United Nations determined to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind, and to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women and of nations large and small, and to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained, and to promote social progress and better standards of life in larger freedom, and for these ends, to practice tolerance and live together in peace with one another as good neighbors, and to unite our strength to maintain international peace and security, and to ensure, by the acceptance of principles and the institution of methods, that armed forces shall not be used save in the common interest, and to employ international machinery for the promotion of the economic and social advancement of all peoples, have resolved to combine our efforts to accomplish these aims. Accordingly, our respective governments, through representatives assembled in the city of San Francisco who have exhibited their full powers found to be in good and due form, have agreed to the present Charter of the United Nations and do hereby establish an international organization to be known as the United Nations. Purposes of United Nations. The purposes of the United Nations are mentioned in Article I of the Charter. They are: A. To maintain international peace and security. The most important purpose of the United Nations is to maintain international peace and security. Article 11 provides that one of the purposes of the United Nations is to maintain international peace and security, and to that end, to take effective and collective measures for the prevention and removal of threats to the peace, and for the suppression of acts of aggression or other breaches of peace, and to bring about, by peaceful means and in conformity with the principles of justice and international law, adjustment or settlement of international disputes or situation which may lead to a breach of peace. This purpose is so important that it led Professor Kelson to remark, "The purpose of the United Nations is world peace." B. To develop friendly relations among nations. Yet another purpose of the United Nations is to develop friendly relations among nations, or respect of the principles of equal rights and self-determination of peoples, and to take other appropriate measures to strengthen universal peace. C. International cooperation in solving international problems of social, cultural, and humanitarian character. The third purpose of the United Nations is to achieve international cooperation in solving international problems of economic, social, cultural, and humanitarian character, and promoting and encouraging respect of human rights and fundamental freedom for all without distinction as to race, sex, language, or religion. D. To make the United Nations a center for the attainment of above common ends. The last purpose of the United Nations is to make it a center for harmonizing the actions of the nations in the attainment of the above-mentioned ends. Principles of the United Nations. Article 2 of the United Nations describes the principles of the United Nations and provides that the organization and its members, in pursuit of the purposes described in Article 1, shall act in accordance with the following principles. 1. The principle of sovereign equality of all members. The first principle of the United Nations is that the organization is based on the principle of sovereign equality of all members. Thus, in the eye of law, all members are equal. It may, however, be noted that it is to an absolute principle and admits certain exceptions. For example, the permanent members of the Security Council possess more powers than other members. For decision on all important matters, in the Security Council the affirmative votes of all the permanent members is essential. Similarly, no amendment of the Charter can take place unless and until it is accepted or ratified by 5 permanent members. 2. Members to fulfill in good faith the obligations assumed by them. The second principle of the United Nations is that all members, in order to ensure to all of them the rights and benefits the membership shall fulfill in good faith the obligations assumed by them in accordance with the present Charter. 3. Peaceful settlement of international disputes. According to the third principle of the United Nations, all members shall settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. 4. Principles of non-intervention. The principle of non-intervention has already been discussed in detail in chapter on intervention. The fourth principle of the United Nations is that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or any other manner inconsistent with the purposes of the United Nations. 5. Members to assist the United Nations in common action. The fifth principle of the United Nations is that all members shall give the United Nations every assistance in common action it takes in accordance with the present Charter, and shall refrain from giving assistance to any state against which the United Nations is taking preventive or enforcement action. 6. Non-members also to act in accordance with the principles of the United Nations for the maintenance of international peace and security. The organization shall ensure that states which are not members of the United Nations act in accordance with these principles so far as may be necessary for the maintenance of international peace and security. 7. Non-intervention in domestic matters of member states. Seventh and the last principle of the United Nations prohibits the United Nations to intervene in the domestic affairs of a member state. This principle, undoubtedly, is a great limitation upon the powers of the United Nations. But the term domestic jurisdiction is very vague. Its meaning changes with the change of time and circumstances. Sometime matters which were considered to be within the domestic jurisdiction of the state at the time of the establishment of the United Nations are now considered matters of international concern. Racial discrimination, apartheid, etc. are glaring examples of such matters. It is, therefore, very difficult to lay down any general guidelines as to what is a matter within the domestic jurisdiction of any state. Q. 113. Is withdrawal of a member from the United Nations possible? Commen. Ans. Membership. Charter of the United Nations provides for two types of members, I. Original members, and 2. States admitted as members according to Article 4 of the Charter. Original members of the United Nations are those members which participated in the United Nations Conference on International Organization at San Francisco or previously signed the United Nations Declaration of 1 January 1942 and subsequently signed the present Charter and ratified it in accordance with Article 110 of the Charter. As regards the admission of members, Article 4 of the Charter provides that a state may be admitted to the United Nations on the affirmative recommendation of the Security Council and by election of the General Assembly by two-thirds majority. Admission of states being an important matter, it is necessary that the Security Council must recommend it by a majority of 9 members including the 5 permanent members. Further, Article 4 provides that for a state to become a member of the United Nations, it must be a state. 2. It must be peace-loving. 3. It must accept the obligations of the Charter. 4. It must be willing to carry out those obligations. And it must be able to carry out those obligations. Is withdrawal of a member state from the United Nations possible? Charter of the United Nations does not provide for the withdrawal of members. It may be noted that the Covenant of the League of Nations contained the following provisions in regard to the withdrawal of members. 1. Any member could withdraw from the League of Nations by giving a 2 years notice. 2. If any amendment was opposed by a member or otherwise not acceptable to it, then it means that particular member ceased to be member of the League of Nations. In San Francisco Conference, 1945, after heated debates, it was finally decided that no provisions regarding withdrawal of the members should be inserted in the Charter. However, a statement of special circumstances was formally issued on which members could withdraw from the organization in special circumstances. Fenwick has expressed the view that members can withdraw from United Nations under the following 2 circumstances. 1. Withdrawal or some form of dissolution could be obviously inevitable if the organization was revealed to be unable to maintain peace or could do so only at the expense of law and justice. 2. If any state did not give its consent for any amendment of the Charter, or gave its vote against the amendment, or found itself unable to accept the amendment, then such a situation may entitle him to withdraw from the organization. In the history of the United Nations, the question of withdrawal of a member from the organization has arisen only once. In January 1965, Indonesia declared withdrawal from the United Nations. Indonesia took this step because Malaysia had been elected as one of the non-permanent members of the United Nations. Indonesia claimed a part of the territory of Malaysia, but her withdrawal was not effective because later on she joined the United Nations as if nothing had happened, as rightly remarked by Michael Akehurst. If her withdrawal had been effective, she would have had to seek readmission under Article 4. Instead, she simply assumed her seat. Nothing had happened to suggest that her withdrawal had been void. Expulsion of a member of the United Nations. Article 6 of the Charter provides that a member of the United Nations which has persistently violated the principles contained in the present Charter may be expelled from the organization by the General Assembly upon the recommendation of the Security Council. Suspension of members. Article 5 of the UN Charter provides that a member of the UN against which preventive or enforcement action has been taken by the Security Council may be suspended from the exercise of the rights and privileges of membership by the General Assembly upon the recommendations of the Security Council. But the exercise of these rights and privileges may be restored by the Security Council. Present number of members. At present, there are 191 members of the UN. Recently, East Timor has been admitted as the new member. Principal organs of the UN. There are the 6 principal organs of the United Nations. 1. General Assembly. 2. Security Council. 3. The Economic and Social Council. 4. The Trusteeship Council. 5. The Secretariat. And 6. The International Court of Justice. Q. 114. Discuss the composition, powers, procedures and functions of General Assembly. Ans. Composition. The General Assembly of the United Nations is the most democratic and representative organ. In a sense, it is the true representative of the people of the United Nations. Each member of the United Nations is represented in it. Each member is entitled to give 1 vote, but may send 5 representatives in the General Assembly. Article 9. At present there are 190 members in the General Assembly. Voting rights. In accordance with the provisions of Article 18 of the Charter, each member of the General Assembly is entitled to give 1 vote. Decisions on important or substantial matters are taken by the majority of 2/3 members important present and voting. According to Article 18, important and substantial questions include maintenance of international peace and security, election of Economic and Social Council, election of members of Trusteeship Council, admission of new states to the United Nations, and suspension and expulsion of the members of the United Nations. As regards to other matters, the decisions of the General Assembly are made by the majority of the members present and voting. Procedure. The annual sessions of the General Assembly may be convened either by the Security Council or by the majority of the members. Article 20. The General Assembly is entitled to formulate its own rules and procedures. Article 21. The General Assembly is also empowered to establish subsidiary organs for the performance of its functions. The session of the General Assembly begins with the discussions on the report of the Secretary General on the work of the organization. Each member is represented in the General Assembly and can send 5 representatives. Consequently, the General Assembly is a big body. It has, therefore, formed certain main and other committees through which it performs its major functions. The committees of the General Assembly are of following types. I. Main committees. 2. Procedural committees. 3. Standing committees. 4. Ad hoc committees. The main committees of the General Assembly generally consider the agenda of General Assembly and prepare recommendations for the General Assembly. Each member of the United Nations is entitled to have its representatives in the main committees. Functions and powers. According to Article 7 of the United Nations Charter, the General Assembly is one of the principal organs of the United Nations. Professor Leonard has classified the powers and functions of the General Assembly under the 5 headings. I. Deliberative functions. 2. Supervisory functions. 3. Financial functions. 4. Elective functions. Constituent functions. Deliberative functions. By deliberative functions we mean the functions of the General Assembly regarding discussions, studies and recommendations and passing resolutions on different matters. The General Assembly performs the following deliberative functions. The General Assembly may discuss any question or any matter within the scope of the present Charter or relating to the powers and functions of any organs provided for in the present Charter. Article 10. There is, however, an exception to this. Article 12 provides that while the Security Council is exercising in respect of any dispute or situation, functions assigned to it in the present Charter, General Assembly shall not make any recommendation with respect to that dispute or situation unless the Security Council so requests. 2. The General Assembly may consider general principles of cooperation in the maintenance of international peace and security, including the principles governing disarmament and regulations of armaments, and may make recommendations with regard to such principles to the members or to the Security Council or to both. Article 11.1. 3. The General Assembly may call the attention of the Security Council to situations which are likely to endanger international peace and security. Article 11.3. 4. The General Assembly has also been entrusted upon important responsibilities under Article 13, which provides that the General Assembly shall initiate studies and make recommendations for the purpose of a. Promoting international cooperation in the political field and encouraging the progressive development of international law and its codification. B. Promoting international cooperation in the economic, social, cultural, education and health fields and assist in the realization of human rights and fundamental freedoms for all without distinction as to race, sex, language or religion. 2. Supervisory functions. By supervisory functions we mean those functions through which the General Assembly supervises the functions of other principal organs and specialized agencies of the United Nations. The General Assembly particularly exercises sufficient control over the two principal organs of the United Nations, namely the Economic and Social Council and Trusteeship Council. The General Assembly exercises control over those organs and performs many supervisory functions in this connection. 3. Financial functions. The General Assembly also performs important financial functions. It considers and approves the budget of the United Nations. Article 17 provides that the General Assembly shall consider and approve the budget of the organization. Article 17 further provides that the expenses of the organization shall be borne by the members as appointed by the General Assembly. Further, the General Assembly shall consider and approve any financial and budgetary arrangements with specialized agencies and shall examine the administrative budgets of such specialized agencies with a view of making recommendations to the agencies concerned. 4. Elective functions. The General Assembly performs two types of elective functions. A. Regarding admission of new states to the United Nations, and B. Election of members for other organs. A. Regarding admission of new states to the United Nations. General Assembly performs important functions in respect of admission of new states to the United Nations. A new state is admitted to UN by decision of the General Assembly by two-thirds majority of the members present and voting upon the recommendations of the Security Council. Besides this, the General Assembly also possesses certain powers in respect of suspension and expulsion of members. B. Regarding election of members for other organs. The General Assembly performs important functions in regard to the election of members for other organs of the United Nations. In this connection, the General Assembly performs the following functions. A. It elects 10 non-permanent members of Security Council. B. It elects 54 members of the Economic and Social Council. C. It also elects some members of the Trusteeship Council. D. It also takes part in the election of the judges of the International Court of Justice, and E. The General Assembly also takes part in the appointment of the Secretary General. In this connection, Article 27 provides that the Secretary General shall be appointed by the General Assembly upon recommendation of the Security Council. Constituent functions. The General Assembly has performed important functions in the social, economic and cultural fields and in the fields of human rights. Thus there has been a constant development of the powers and functions of the General Assembly. Q. 115. What do you know about the composition, powers and functions of Security Council? Ans. Composition. The Security Council is one of the principal organs of the United Nations, which comprises of 15 members, out of which 5 are permanent and 10 are non-permanent members. China, Russia, America, France and Britain are the permanent members of the Council. The 10 non-permanent members are elected by the General Assembly for a term of 2 years. Each member state is entitled to send one representative in the Council. Voting rights. Each member of the Security Council is entitled to give one vote. Decisions on procedural matters are taken by a majority of 9 members. Decisions on important and substantial matters require the affirmative vote of 9 members, including of 5 permanent members. If any permanent member give a negative vote, called veto, the Security Council becomes unable to take decision on that matter. When the Security Council has taken decision on the matter related to Article 62 Para 3 of the Chapter 6, the party to the dispute cannot participate in the voting. And maintenance of international peace and security. For detailed study see S.K. Kapoor, Maintenance of International Peace and Security, Lawyer, Nov. 1972, p. 170. In order to ensure prompt and effective action by the United Nations, state members have conferred upon the Security Council the primary responsibility for the maintenance of international peace and security. The members have also agreed that in carrying out its duties the Security Council acts on their behalf. Article 24 of the UN Charter. The members of the United Nations have also agreed to accept and carry out the decisions of the Security Council with the least diversion for the armaments and the world's human and economic resources. The Security Council is also responsible for formulating, with the assistance of the military staff, plans to be submitted to the members of the United Nations for the establishment of a system of regulation of armaments. Article 26. 2. Elective functions. The Security Council also performs some elective functions. For example, Security Council and the General Assembly separately elect the judges of the International Court of Justice. In this way, the Security Council participates in the election of the judges of the World Court. Besides this, the Security Council also recommends the appointment of the Secretary General of the United Nations. 3. Supervisory functions. The Security Council also performs some supervisory functions. That is to say, it supervises the functions of the organization as a whole, although its supervisory functions are not as wide as that the General Assembly. But since it has been conferred upon some very important functions in regard to file expulsion and suspension of members, it may not be wrong to contend that through this it exercises supervision upon the United Nations as a whole. Last but not the least, the Security Council is responsible for control and supervision of the strategic areas of the trust territories under the trusteeship system of the United Nations. 4. Constituent functions. The constituent powers of the Security Council are very important. Article 108 of the Charter provides that amendments to the present Charter shall come into force for all members of the United Nations when they have been adopted by a vote of 2/3 of the members of the General Assembly, and ratified in accordance with their respective constitutional processes by members of the Security Council. It is clear from this that no amendment of the Charter is possible unless and until all the permanent members of the Security Council give their affirmative vote on it, and it is subsequently ratified by their respective. Q. 116. Is there any need for enlargement of Security Council? Discuss with reference to claim of India. Ans. Need for enlargement of the Security Council with a view to reflect the increased strength of the General Assembly and the new power configuration in the world after the Gulf War, 1991, and the breaking up of the Soviet Union. The need for democratization of the UN system has emerged as a recurrent theme. One way of democratization the UN would be by reviewing the membership of the Security Council. When the membership of the Security was increased from 11 to 15 in 1965, the membership of the UN was 113. Since then the membership of the UN has increased to 190 at present, but the membership of the Security Council remains the same. Besides this, there are other imbalances in the existing composition of the Security Council. Africa and Latin America are unrepresented. China is the representative of Asia, the largest continent from the point of area and population. The two economic superpowers Germany, especially after the unification of two Germanys, and Japan, which alone contributes 12.5% of the UN's total budget, nearly half the US contribution and larger than what Britain and France are together giving to it, are not the permanent members. Moreover, some developing countries like India and Brazil have acquired international status. In view of these reasons, the membership of the Security Council ought to be increased from 15 to 25, including 10 permanent members. The new 5 permanent members should be chosen from amongst the countries such as Japan, Germany, India, Egypt, Brazil, and Nigeria. Besides this, 5 new non-permanent members should be elected on geographical basis to make the Security Council more representative. On 12 December 1992, the United Nations General Assembly passed a resolution asking the Secretary-General to seek views of member states on equitable representation and increasing the membership of the Security Council. The resolution seeks a report from the Secretary-General, Dr. Boutros Ghali, before the next session of the Assembly, i.e., September 1993. It may, however, be noted that none of the 5 permanent members, the US, Russia, UK, China and France, whose recent expansion of their exclusive club, joined in sponsoring the resolution. Obviously, any change in the structure of the Security Council would need approval of all the 5, as they have the power to veto any such resolution. Even a suggestion made in diplomatic circles that new members may be given veto power did not find favor among the 5. There is no denying the fact that for any amendment of the Charter, affirmative votes of 5 permanent members is essential. It is therefore necessary to build public opinion and to put pressure on the existing 5 permanent members, and especially on the US, before in the present unipolar world much will depend on the attitude adopted by the US, the sole superpower. A consensus seems to have emerged that both Japan and Germany should be made permanent members. Japan is even prepared to increase its contribution to the UN if it is made a permanent member. As regards India, after initial opposition, the US has now agreed that there ought to be a permanent member from Asian region, and this region should itself decide about its member. But this proposal is not acceptable to India, who has already put forward its claim formally. India's claim for permanent membership of the UN is backed by a considerable number of countries. Besides India, Egypt, Brazil and Nigeria are other strong contenders for permanent membership of the UN. Q. 117. What do you know about veto and its effects on the efficiency of Security Council? Ans. Veto and its effect on the efficiency of the Security Council. In accordance with the provisions of Article 27 of the Charter, the affirmative vote of 9 members of the Security Council, including the permanent members, is necessary for a decision on substantive or important matters. In other words, we may say that China, Russia, America, Britain and France, the permanent members of Security Council, have been conferred upon the veto power. The right of veto given to the permanent members of the Security Council has greatly impaired the efficiency of the Security Council. Because of this, the Security Council has become a weak organ of the United Nations and has not been able to perform functions entrusted to it under the Charter. It is often claimed that Security Council was responsible for stopping the North Korea from overrunning South Korea in 1950. But as remarked by Professor Goodspeed, nothing could be more misleading since the United States was able to obtain United Nations blessing for military action on that occasion because the Soviet delegate had absented himself from the Security Council and could not interpose his veto in time. When the Soviet representative returned to the Security Council, the Security Council became unable to take any further action in Korea. Similarly, in other important matters, the Security Council is not able to perform its functions of maintenance of peace and security because of the exercise of veto power. An example of this is the Indo-Pak War of 1971. In the beginning, the Security Council could not take any decision because Russia exercised its veto in favor of India. Thus, the veto has greatly impaired the efficiency of the Security Council. But there does not seem to be any alternative to it because the permanent members are not prepared to give up this privilege. Thus the system can be termed as necessary evil. Since it is very difficult to remove this necessary evil, efforts should be made to find out procedures and methods through which the abuse of this right may be checked or at least restricted. Q. 118. Discuss the contribution of Security Council for the maintenance of peace and security in the world. Ans. Contribution of the Security Council for the maintenance of peace and security. As pointed out earlier, the veto has greatly affected the efficiency of the Security Council. But it would be wrong to contend that the Security Council has not made any contribution for the maintenance of international peace and security. As a matter of fact, the Security Council has been able to perform its functions properly in cases where the interests of the permanent members were not directly involved. In such cases, the Security Council has performed creditable functions. The Security Council has been able to contribute to the maintenance of peace and security in cases of Indonesia, 1949, Palestine problem, Indo-Pak conflicts, 1948, 1965 and 1971, Congo, 1960, Cyprus and Arab-Israeli conflicts, 1973, Iran-Iraq War and Gulf War, 1991. It would, therefore, be wrong to say that the Security Council has proved to be a complete failure. It has been successful in a number of cases to prevent escalation of armed conflict and to effect ceasefire. It is also one of the great achievements of the Security Council that since the inception of the United Nations there has been no world war. However, the Security Council has been successful only to prevent escalation of war and, to effect temporary ceasefires. It has failed to find out permanent political solutions of the problems. This has been mainly due to mutual fears and distrust, non-cooperation and conflict among great powers. Q 119. Define double veto. Ans. Double veto. Article 27 provides that the decisions of the Security Council on all important matters shall be made by an affirmative vote of 9 members, including the concurring votes of permanent members. That is to say, no important decision can be taken by the Security Council unless and until 5 permanent members give their affirmative votes. Whenever a question arises whether a matter is procedural or substantial, double veto may be used. By double veto we mean the permanent members of the Security Council can use their veto 2 times. Whenever a matter or resolution is to be voted, the President of the Security Council determines the procedure of voting and rules whether only 9 affirmative votes are required or whether these 9 affirmative votes should include the affirmative votes of the 5 permanent members. In other words, in the first place, it is the President of the Security Council which gives his decision as to whether the matter is substantial or procedural. The decision of the President of the Council can be challenged. If any permanent member of the Security Council challenges the said decision of the President of the Council or it gives negative vote or veto against such decision, the matter which the President ruled as procedural becomes substantive. This is the first item when a permanent member can use his veto. Once a matter becomes substantive, a decision on it can be vetoed by any permanent member of the Security Council. This is the second time when a permanent member can use his veto. Thus a permanent member can use his veto 2 times, and this is generally known as double veto. Russia used double veto on the question of Greece, Czechoslovakia and Spain. The essence of double veto has been aptly summed up by Professor Goodspeed in the following words. The essence of veto is to maneuver the Council in voting whether a question is substantive or not. The veto is possible on such a vote which thereby guarantees that the question will become substantial if so desired. Once declared substantive, the question itself can be vetoed. Q 120. Discuss the relationship between Security Council and General Assembly. Ans. Relationship between Security Council and the General Assembly. In accordance with the provisions of Article 7 of the Charter, both Security Council and General Assembly are the principal organs of the United Nations. These 2 organs occupy a place of prominence in the whole setup of the United Nations. Many matters under the Charter require recommendations of the Security Council and a decision of the General Assembly. That is to say, no decision can be taken on such matters unless the Security Council has recommended and a General Assembly has also concurred with that decision. For example, the Security Council and the General Assembly separately elect the judges of the International Court of Justice. Besides this, their participation is necessary for admitting a new state to the United Nations. A new state can be admitted to the United Nations only when the General Assembly elects it by two-thirds majority upon the recommendation of the Security Council. Similarly, both participate in the suspension and expulsion of members. All these matters can be decided only when there is an affirmative recommendation of the Security Council and concurring decision of the General Assembly. Similarly, the Secretary General is appointed by the General Assembly on the recommendations of the Security Council. Moreover, there are certain other provisions under which the Security Council and the General Assembly are connected with each other. The Security Council sends its annual report to the General Assembly. The budget of the Security Council is also passed by the General Assembly. So far as the maintenance of world peace and security are concerned, its primary responsibility rests upon the Security Council. Article 24. But if Security Council fails to perform its functions or fails to make its affirmative recommendation in regard to any conflict, the General Assembly may step in and perform certain functions relating to peace and security. These powers have been conferred upon the General Assembly under the Uniting for Peace Resolution 1950. Thus we see that the General Assembly and Security Council are intimately connected with each other. In fact, the United Nations can achieve its objective only when these two principal organs of the United Nations cooperate with each other in solving the problems confronting the organization. Q. 121. What is the binding character of resolution of Security Council? What are its limitations? Ans. Binding character of the resolution of Security Council. The resolutions of the Security Council are binding upon the members. This is evident from Article 25 of the Charter, which provides that the members of the United Nations agree to accept and carry out the decisions of the Security Council in accordance with the present Charter. There is no controversy in respect of the binding effect of the resolutions of the Security Council relating to enforcement measures under Chapter 7 of the Charter. But there is some controversy in respect of the binding character of other decisions of the Security Council, especially those made under the provisions of the Charter relating to international disputes and dangerous situations. In advisory opinion concerning the legal consequences for states of the continued presence of South Africa in Namibia, Southwest Africa. Notwithstanding Security Council Resolution 270, 1970, ICJ reports, 1971, p. 16, the International Court of Justice laid these doubts to rest. The World Court observed, it has been contended that Article 25 of the Charter applies only to enforcement measures adopted under Chapter 7 of the Charter. It is not possible to find in the Charter any support for this view. Article 25 is not confined to decisions in regard to enforcement action but applies to the decisions of the Security Council adopted in accordance with the Charter. Moreover, that article is placed, not in Chapter 7, but immediately after Article 24 in that part of the Charter which deals with the functions and powers of the Security Council. If Article 25 had reference solely to decisions of the Security Council concerning enforcement actions under Articles 41 and 42 of the Charter, is to say, if it were only such decisions which had binding effect, then Article 25 would be superfluous, since the effect is secured by Articles 48 and 49 of the Charter. ICJ reports 1971 at pp. 52 to 53. But this was all advisory opinion of the court, and some states, particularly France, pointed out that it was consultative opinion and not a decision. Italy approved court's opinion in respect of Namibia but disagreed with the court's interpretation on Articles 25 and 24 of the Charter. After detailed discussion on the court's opinion, the Security Council adopted by 13 votes to the court's opinion-wide Resolution 301, 1971. As pointed out by all author S. Azadon Tool, binding decisions of the Security Council within the meaning of Article 25 of the United Nations Charter, Ujil Volume 15, 1975, p. 195 at p. 213. However, this was perhaps not conclusive of the matter. The abstaining states, for instance, explained that they had abstained because they could not support a resolution which implicitly accepted the advisory opinion of the International Court of Justice. Further, in conclusion, it should be observed that the controversy as to the scope of Article 25 persists, at least in the attitudes of several states, and that the majority view in the Namibia advisory opinion has not been accepted as a definite disposal of the issue. Despite some controversy, the correct legal position seems to be, as has been stated by the International Court of Justice, the decisions of the Security Council in respect of enforcement measures under Chapter 7 as well as other decisions are binding upon the member states by virtue of the provisions enshrined in Article 25 of the Charter. Q. 122. Define composition, voting rights, powers and functions of Economic and Social Council. Ans. Composition. Originally, the Economic and Social Council comprised of 18 members elected by the General Assembly. In the year 1963, the Charter was amended and the membership of the Economic and Social Council was increased to 27. It came into force on 31 August 1965. In the year 1971, the Charter was once again amended and the membership of the Council was increased to 54. It came into force on 24 September 1973. At present, the Economic and Social Council comprises of 54 members. Since the membership of the UN has now swelled to 190, a plea can be made for further increase in the membership of the Economic and Social Council. Voting. Each member of the Economic and Social Council is entitled to have one vote. The decisions of the Council are made by a majority of members present and voting. Powers and functions. The Economic and Social Council performs the following functions. 1. The Economic and Social Council may make or initiate studies and reports with respect to economic, social, cultural, educational, health and related matters, and may make recommendations with respect to any such matters to the General Assembly, to the members of the United Nations, and to specialized agencies concerned. Article 62.1. 2. It may make recommendation for the purpose of promoting respect for and observance of human rights and fundamental freedoms for all. Article 62.2. 3. It may prepare draft conventions for submission to the General Assembly with respect to matters falling within its competence. Article 62.4. 4. It may call, in accordance with the rules prescribed by the United Nations, International Conference on Matters Falling Within its Competence. Article 62.4. 5. The Economic and Social Council may furnish information to the Security Council and shall assist the Security Council upon its request. Article 65. 6. The Economic and Social Council shall perform such functions as fall within its competence in connection with the carrying out of the recommendations of the General Assembly. Article 66.1. 7. It may, with the approval of the General Assembly, perform services at the request of the members of the United Nations and at the request of the specialized agencies. Article 66.2. 8. It shall also perform such other functions as are specified elsewhere in the present Charter or may be assigned to it by the General Assembly. Article 66.3. The Economic and Social Council helps in the establishment of world peace by improving the lot of the poor, wounded, and illiterate people. It endeavors to improve the life of the people in many respects. Besides the above-mentioned functions, the Economic and Social Council is responsible for improving the standard of living of the people, to provide full employment, and to develop social and economic conditions of the world. Q. 123. Explain the composition, voting, powers and functions of the Trusteeship Council. Ans. Composition. As provided under Article 86 of the UN Charter, Trusteeship Council comprises of the following members of the UN. A. Those members who are administering trust territories. B. The permanent members of the Security Council as are not administering the trust territories, and C. As many other members elected for 3 years term by the General Assembly as may be necessary to ensure the total number of members of the Trusteeship Council is equally divided between those members of the United Nations which administer trust territories and those which do not. Voting. Each member of the Trusteeship Council possesses one vote. The decisions of the Trusteeship Council are made by a majority of the members present and voting. Functions and powers. Trusteeship Council performs the following functions under the authority of the General Assembly. 1. It may consider reports submitted by the administering authority. 2. It may accept petitions and examine in consultation with the administering authority. 3. It may provide for periodic visits to the respective trust territories at times agreed upon with the administering authority. 4. It may take these and other actions in conformity with the terms of the trusteeship agreement. 5. The Trusteeship Council shall formulate a questionnaire for each trust territory within the competence of the General Assembly and shall make annual report to the General Assembly upon the basis of such questionnaire. Article 88. 6. The Trusteeship Council may avail itself of the assistance of the Economic and Social Council and of the specialized agencies in regard to matters with which they are respectively concerned. Article 91. The Trusteeship Council has done commendable work. The number of inhabitants living in trust territories has been constantly decreasing every year. The work of the Trusteeship Council is rapidly lessening. It would not be wrong to foresee that in a very near future the Trusteeship Council will probably have no work at all to do. At present, it simply receives reports from the United States as the administering authority of the sole remaining trust territory, the Pacific Islands, of which the future of Palau has remained undecided. It is one of the principal organs of the United Nations which has almost successfully completed its work. Leaving aside the case of Southwest Africa, it has achieved success almost in all the trust territories which were under its control and auspices. Q. 124. Define the composition, powers and functions of the Secretariat. Ans. According to Article 7 of the United Nations Charter, the Secretariat is one of the principal organs of the United Nations. Composition. The Secretariat comprises of a Secretary General and such staff as the organization may require. The Secretary General is appointed by the General Assembly upon the recommendation of the Security Council. He is designated as the Chief Administrative Officer of the organization. Article 97. It is pertinent to note that he is not only the Chief Administrative Officer of the Secretariat but of the whole organization. Kofi Annan of Ghana is the Secretary General of UN. He has become Secretary General at a time when the UN is confronted with several formidable problems, the most formidable of them being financial crisis and Iraq-America conflict. In order to maintain the international character of the Secretariat and to make it impartial, the Charter clearly provides that the Secretary General and his staff shall not take direction from any government, and the member states of the United Nations shall also respect exclusively international character of the responsibilities of the Secretary General and the staff, and shall not seek to influence them in the discharge of their responsibilities. Article 100. The staff of the Secretariat is appointed by as the Secretary General in accordance with the rules determined and established by the General Assembly. Functions of the Secretary General. For detailed study, see also S.K. Kapoor, Constitutional and Legal Norms Governing the Rule of Secretary General and His Functions, 1973. SCJ 1st March 1973, p.5. The Secretary General performs the following functions. 1. The Secretary General is the Chief Administrative Officer of the organization. Article 97. 2. The Secretary General acts in the capacity of the Chief Administrative Officer of the organization in all meetings of the General Assembly, of the Security Council, of the Economic and Social Council, and of the Trusteeship Council, and performs such other functions as are entrusted to him by these organs. Article 98. 3. The Secretary General makes annual report to the General Assembly on the work of the organization. In fact, the annual session of the General Assembly begins with the discussion of the report of the Secretary General on the work of the organization as a whole. 4. The Secretary General may bring to the notice of the Security Council any matter which in his opinion threatens the maintenance of international peace and security. Article 99. 5. The Secretary General gets collected all the statistics in regard to the economic conditions of the whole world and submits those data to the Economic and Social Council. Conclusion. However, there are certain limitations on the functions and capacities of the Secretary General. The Secretary General cannot be successful in the performance of functions relating to the maintenance of peace and security until there is cooperation among the major powers, namely, the permanent members of the Security Council. Yet the fact remains that as an effective instrument of conciliation in the hands of principal organs of the UN such as the Security Council and the General Assembly, and as a mediator for the member states, the office of the Secretary General has become very important, rather indispensable. Q. 125. Discuss the composition and jurisdiction of International Court of Justice. Ans. Composition. According to Article 7, International Court of Justice is one of the principal organs of the United Nations. It is the chief judicial organ of the United Nations and is based upon a statute which is integral part of the United Nations Charter. Article 92. All members of the United Nations are ipso facto the members of the Statute of the International Court of Justice. Any state which is not a member of the United Nations may also become a party of the Statute of the International Court of Justice on the recommendation of the Security Council and on the conditions laid down by the General Assembly. Article 93. The International Court of Justice consists of 15 judges which are elected by the General Assembly and the Security Council separately. These judges are elected for a term of 9 years and can also be re-elected after the expiry of their term. All the decisions of the court are made on the basis of the majority of the judges. The President of the court is empowered to give casting vote in case of a tie. Law applied by the International Court of Justice. According to Article 38(1) of the Statute of the International Court of Justice, the court shall decide the disputes submitted to it in accordance with international law and shall use the sources of international law in the following order. 1. International conventions. 2. International customs. 3. General principles of law recognized by civilized nations, and 4. Judicial decisions or the works of jurists, etc. as a subsidiary means determining the rule of international law. Binding force of the decisions of the International Court of Justice. According to Article 59 of the Statutes of the International Court of Justice, the decisions of the court shall not have a binding force except upon the parties to dispute and only in respect of a particular dispute between them. Jurisdiction. The International Court of Justice is open for all states of the world. Only the states may be a party to any dispute before the court. Individuals cannot be a party to a dispute before the court. International organizations may request the court to give advisory opinion on legal matters. Broadly speaking, the jurisdiction of the court may be divided into the following two main heads. I. Contentious and 2. Advisory. I. Contentious jurisdiction. Contentious jurisdiction may be further divided into the following two heads. 1. Voluntary jurisdiction and 2. Optional jurisdiction. 1. Voluntary jurisdiction. In accordance with Article 36(1) of the Statute of International Court of Justice, the court has jurisdiction over all such cases which the parties entrust to it, and also those matters which are expressly mentioned to be within the jurisdiction under the United Nations Charter or under international treaties. This type of jurisdiction is called voluntary jurisdiction. 2. Optional jurisdiction. Article 36(2) of the statute confers optional jurisdiction upon the court, which provides that the existing parties to the statute may confer compulsory jurisdiction upon the court by making such declaration in respect of any other state which also accepts similar obligations. This can be done without any special agreement to the same effect. This is called optional jurisdiction of the court. Under this provision, the state party to the statute may confer compulsory jurisdiction upon the court in respect of the following matters. 2. Advisory jurisdiction. The International Court of Justice may also give advisory opinion to the Security Council and the General Assembly and also to other organs of the United Nations and the specialized agencies of the United Nations if they are authorized by the General Assembly in this connection under Article 96 of the UN Charter. Article 65 of the Statute of the International Court of Justice provides that the court may give an advisory opinion on any legal question at the request of whatever body may be authorized by or in accordance with the Charter of the UN to make such a request. Article 68 of the statute further provides that in the exercise of its advisory functions the court shall further be guided by the provisions of the present statute which apply in contentious cases to the extent to which it recognizes them to be applicable. Q. 126. What are the problems for the enforcement of judgments of International Court of Justice? Ans. Problems for the enforcement of the judgments of the International Court of Justice. Under Article 94 of the UN Charter, the Security Council is empowered to implement the judgments of the International Court of Justice in case one of the parties fails to implement it and the other party to the dispute brings the matter to the Security Council. The problem of enforcement of the judgments of the World Court which came before the UN was not experienced by the League of Nations. For example, in Corfu Channel case, ICJ reports 1949 p. 4, Albania refused to implement the decision of the court. A similar problem arose in nuclear test case, ICJ reports 1973 p. 106. This problem also arose when on 15 December 1979, the International Court of Justice indicated provisional measures in case concerning United States diplomatic and consular staff in Tehran, US v. Iran. The framers of the Charter were of the view that enforcement of judgments was not the function of the court, and they entrusted this work to the Security Council. However, as pointed out by Fawcett, except in Corfu Channel case, the problem of the enforcement never seriously arose, and even in that case on the refusal of Albania to pay compensation, England had confiscated Albanian money in England. Recently, the problem of the enforcement of judgments of the court has once again assumed serious magnitude in the case concerning military and paramilitary activities in and against Nicaragua, Nicaragua v. U.S. On refusal of the U.S. to comply with the decision of the court, Nicaragua invoked Article 94, Paragraph 2 of the UN Charter. Thus, there are not more than a few cases out of many hundreds which have involved the refusal by the losing party to give effect to an award rendered. Though Charter has empowered Security Council to implement the decision of the court if one of the parties to dispute before the court, it is doubtful whether it will be able to exercise this power effectively if the losing party is one of the permanent members of the Security Council or even a member of the UN which has the support of any such permanent member. The case of Nicaragua v. U.S. 1986 is a glaring example of this. Q. 127. Define. A. ILO. B. WHO. C. UNESCO. ANS. A. International Labour Organization, ILO. International Labour Organization was established in 1919 as an autonomous partner of the League of Nations. Its head office is situated in Geneva. It was brought into relationship with the United Nations in 1946 through a special agreement. This special agreement was approved by the General Assembly on 14 December 1946. International Labour Organization functions in close collaboration with the United Nations. Composition and functions. Its membership is open for all the states. In 1970 it had 121 states as its members. Following are the main organs of the International Labour Organization. A. General Conference. Each member state gets representation in the General Conference. Each state has 4 representatives in the General Conference to representatives of the state government and 1 each representative of the workers and employees. Each representative has 1 vote. Most of the decisions of the conference are in the form of conventions and recommendations, and they require the majority of 2/3 members present and voting. B. Governing body. The governing body comprises of 54 members and is a tripartite body and includes the representatives of state governments, employers and workers. The governing body appoints the Director General and supervises the functions of the organization. C. International Labour Offices or Secretariat. The head of the International Labour Office is a Director General. Its head office is situated in Geneva and its branches are in New York and in several countries of Europe and Asia. Its main function is to collect information related to industrial life and labor and to assist the members to make laws in accordance with the decisions of the General Conference. ANS. B. World Health Organization, WHO. As pointed out by Professor Stephen S. Goodspeed, the World Health Organization is typical of the specialized agency with multipurpose functions and well-defined objectives. Objectives and functions. The main function of the World Health Organization is to raise the standard of health of the people. A. Assembly. It comprises of all the members. Its session is held every year and each member has one vote. However, each member is entitled to have 3 representatives in the Assembly. The Assembly lays down the general policy and passes the budget of the organization. B. Executive Board. This is a technical and non-political organ. It comprises of 24 members who possess high technical education in the field of health and who are elected by the Assembly. It holds its session twice in a year and implements the decisions taken by the Assembly. C. Secretariat. The Chief of the Secretariat is a director who is appointed by the Assembly. He is also the chief and the technical officer of the organization. The World Health Organization has rendered signal services by its endeavors to eradicate diseases and to raise the standards of health of the people of the world. It performs both advisory and technical functions. It has performed commendable work in checking diseases such as malaria, TB and influenza. This organization also gets research work done for the solution of worldwide problems relating to health. UNS. C. United Nations Educational, Scientific and Cultural Organization. UNESCO. For the establishment of the United Nations Educational, Scientific and Cultural Organization, a conference was held in London in November 1945. It was finally established on November 14, 1946. Thereafter it was brought into relationship with the United Nations through a special agreement which was approved by the General Assembly on December 14, 1946. Objectives and functions. The United Nations Educational, Scientific and Cultural Organization has laid a great emphasis on the development of basic education. It also encourages research work in the field of science. It has rendered signal services for the development of knowledge and its dissemination. In order to achieve these objectives, it assists state and non-state institutions. Composition. Each member of the United Nations can become its member. Other states may be made the member of the United Nations Educational, Scientific, and Cultural Organization through two-thirds majority of General Conference. Following are the main organs of the United Nations Educational, Scientific, and Cultural Organization. A. General Conference. All the member states get representation in the General Conference, which holds its sessions twice in every year. It is the policy-making organ of the United Nations Educational, Scientific, and Cultural Organization. For adopting international conventions, two-thirds majority is required, but only simple majority is required for adopting recommendations. The General Conference elects the members of the Executive Board and appoints the Director General of the Secretariat. B. Executive Board. It comprises of 24 members who are elected by the General Conference for a term of 4 years. Its chief function is to implement the decisions of the General Conference. C. Secretariat. The Chief of the Secretariat is a Director General who is elected by the General Conference on the nomination of the Executive Board. The Director General participates in the meetings of the General Conference, the Executive Board's meeting of the technical committees, and performs routine functions of the organization. Q. 128. Define. A. FAO. B. ICAO. C. IBRD. D. IMF. ANS. A. Food and Agricultural Organization, FAO. It was established on 16 October 1945 when its constitution was adopted. Thereafter, it was brought into relationship with the United Nations, and this agreement was approved by the General Assembly in December 1946. Objectives and functions. It aims to raise the living standards, to increase the production of foodstuffs, and to enhance the capacity of their distribution, to improve the conditions of the rural population and thus to improve the economic system of the world. In order to achieve these objectives, the organization performs various types of technical functions. It collects information related to food and agriculture and disseminates them. It also assists the member states in their endeavors to increase production of foodstuffs. Composition. The following are the three main organs of the Food and Agricultural Organization. A. Conference. B. Council, and C. Director General. The conference is the representative body and is represented by the member states. It lays down the general policy of the organization. The council comprises of 27 members who are elected by the conference. The council elects its president. The Director General is appointed by the conference. ANS. B. International Civil Aviation Organization, ICAO. From 1st November to 7th December 1944, an International Civil Aviation Conference was held in Chicago. In this conference, it was decided to establish an International Civil Aviation Organization. It was finally established on 4th April 1947. The chief aim of this organization is to encourage and develop international civil aviation. This organization has the following main organs: A. Assembly, B. Council. The Assembly is the representative body and all the member states are its members. The Council comprises of 27 members which are elected by the Assembly for a term of 3 years. The Council collects informations for the development of international civil aviation, conducts investigations, and publishes information relating to civil aviation. It also makes recommendations in regard to the standards and practices of the international civil aviation. If on account of certain circumstances there are obstructions in international civil aviation, the Council conducts investigations and acts as an arbitration council to decide the disputes amongst the states. A leading case relating to International Civil Aviation Organization is ICO jurisdiction case, India v. Pakistan, ICJ reports, 1972, pp. 46 ff. The facts and decision of this case have been discussed under the chapter on aircraft hijacking. Ans. See International Bank for Reconstruction and Development, Bank, IBRD. It was established on 27 December 1946. Therefore, it was brought into relationship with the United Nations through a special agreement which was approved by the General Assembly on 15 November 1947. Its main objective is to assist the member states in reconstruction and development by investing capital. It also encourages investment of foreign capital by giving guarantee for the same. It also aims to encourage the balanced development of international trade. Its membership is open for all those states who were the members of International Monetary Fund before 31 December 1945. Others may be admitted as members through the majority decision of the Board of Governors. The bank has the following main organs: A. Board of Governors, B. Executive Directors, and C. President. The Board of Governors comprises of a governor and an alternate member. It is constituted for a term of 5 years and holds its session once in a year. All the powers of the bank are concentrated in the board. The board has delegated its powers to 18 executive directors who perform the general functions of the bank. The executive director elects a president who is responsible to the organization and presides over the meetings of the executive directors. Ans. D. International Monetary Fund, IMF. It was established in December 1945 and was brought into relationship with the United Nations through a special agreement in November 1947. Its main functions are to encourage the balanced development of international trade, to establish exchange system of foreign exchange among the members, and in this connection endeavors to discourage mutual competition, to make available funds to members and thereby creating confidence in them so as to minimize the inequalities in the matters of international payments, etc. Besides the original members, other states may be admitted as members by simple majority of the Board of Governors. The capacity of a member state to cast votes is in accordance with the money deposited by it in the fund. Besides 250 votes, each states may give one additional vote for $100,000,000 deposited by it in the fund. International Monetary Fund has the following main organs. A. Board of Governors. B. Executive Directors and C. Managing Director. All the powers of the International Monetary Fund are concentrated in the executive directors, who elect one managing director from amongst themselves. There are 18 executive directors, and the executive directors are responsible for the general functions of the organization. The managing director acts as the chairman of the executive directors. The head office of the International Monetary Fund is in Washington. It may be noted here that in spite of the International Monetary Fund settling of the three crucial issues facing it, the rich and the powerful countries still retain the last word in decision-making, a point about which India and other developing countries are rather so. The two issues it has settled are the role of gold and the quotas and voting rights of member countries. As regards the voting rights, both the IMF and the World Bank have recently increased the share of the members of petroleum exporting countries. The share of the US has been reduced from 23% to 20%, but it still retains the veto power. However, it now requires a vote of 3/5 of the members with 85% instead of 80% of the voting rights to change the rules of the fund. It is argued that the developing countries should be happy that the increase in the total size of the fund quotas from $29 billion to $39 billion should give the IMF additional resources for everything it needs, including more money with which to help the poor. But the concept that an increase in the additional resources of the IMF means an increase in development and is being questioned on the premise that the agreement on gold would be to the advantage of the developing countries. While a sum of $3 billion may ultimately be available to the developing countries, it has already been pointed out that it will be a one-shot affair and not the same as the link sought by India and others between S.D.Rs and development assistance. The official price of gold, which was S.D.Rs an ounce, or about $42, has been abolished. The obligation of countries to use gold in their transactions with the fund has also been abolished. The Secretary of the U.S. Treasury, Mr. William E. Simon, hailed these steps as having settled the thorny issue involved in phasing gold out of the international monetary system, while India's Finance Minister Mr. C. Chidambaram criticized the arbitrary manner in which it has been done. It may, therefore, be concluded that despite the recent changes in the IMF, the rich and the powerful countries still retain the last word in decision-making. IMF loan of $5.68 billion for India. On 9 September 1981, the IMF gave its approval for $5.68 billion loan to India, which is its largest loan in history. This loan has been given to India to meet its current balance of payments problems created by higher import costs of oil and other items. India suffered a 4 billion deficit in its balance of payments in the year 1980 mainly because of oil imports, which accounts for 40% of her total imports. Request of IMF loan by India due to Gulf War, 1991, and balance of payment problem. The hike in petroleum prices due to Gulf War, 1991, had brought an unprecedented financial crisis for India and has forced India once again to request IMF to grant considerable amount of loan to bail India out of the present crisis. India has thus fallen into the debt trap, for it has to seek further loan to pay installments and interests of earlier loans. Q 129. What do you mean by the expression human rights? Define it as defined in Indian statutes and international covenants. Ans. Meaning. Human rights have been talked about in our society many a time. Recently, its importance has been increased as more and more people are becoming aware about human rights. In order to understand the correct and national meaning of the term human rights, we are to understand the meaning of the word human. In Chambers' 20th Century Dictionary, the word human has been explained to mean belonging or pertaining to man, having the qualities of a man. In Oxford Advanced Learners' Dictionary, the word has been said to mean of or characteristics of people, contracted with God, animals or machines. The meanings assigned in Chambers' Dictionary as having qualities of a man and in Oxford Dictionary as contrasted with God, animals or machines lead to the conclusion that the persons who do not possess the qualities of man but behave as wild animals, like the extremists, who behave as animals or in a mechanic have take massacring people, cannot claim to be human beings and protection or shelter of human rights. Human rights are for humans and not for animals or extremists or hardened criminals. Now let us consider the definitions of human right as given in the Indian and the international statutes and covenants. Under the Human Rights Protection Act, 1993 of India, human rights mean the rights relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution, or embodied in the international covenants and enforceable by courts in India. Under the International Covenants on Human Rights, the Universal Declaration of Human Rights, 1948, is the basic and the most important covenant on the subject. But this covenant does not define human rights and leaves it to be interpreted by the great powers according to their choice and impose them on weak, poor and developing nations. Article 1 of the Declaration declares that all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. This provision is an anomaly in its own terms. Are the extremists, terrorists, and fundamentalists entitled to claim human rights who have proved themselves to be brutes to human society? Common sense and humanity is beyond their conception. That is why the Indian Act on Human Rights does not accept the concepts of human rights as they have been declared under the Universal Declaration of Human Rights. Under the Indian law, only those rights are accepted to be the human rights which are enforceable by courts in India. Section 2(d) of the Protection of Human Rights Act, 1993 very wisely defines human rights to mean the rights relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. The instrument of accession by India to the Human Rights Covenants, 1979, also declares with reference to Article 9 of the International Covenant on Civil and Political Rights that the Government of the Republic of India takes the position that the provisions of this article shall be so applied as to be in consonance with the provisions of Article 22, 3 to 7 of the Constitution of India. Further, under the Indian legal system, there is no enforceable right to compensation for persons claiming to be victims of unlawful arrest or detention against the state. With respect to Articles 4, 7, 12, 13, 19, 3, and 22 of the Covenant, it is declared that Republic of India accedes to same, subject to the declarations made by it. Q. 130. Trace the origin and development of human rights in the world with special reference to India. Ans. The origin of the concept of the human rights may be traced far back in the Babylonian laws, Assyrian laws, Hetli laws, and the Dharma Shastra in the Vedic period of India. Plato and other Greek and Roman philosophers also advocated the atoms of human rights. In the city-state of Greece there was freedom of speech, equality before law, right to vote, right to be elected to a public office, right to trade and right of access to justice to the citizens. Romans also secured similar rights to their citizens by jus civili, civil law of the Romans. Magna Carta was granted by King John of England to the English barons on 15 June 2012, 15, which ensured feudal rights and dues and the guarantee that the king would not encroach upon their privileges. This document set for the principle that the power of the king was not absolute. In 1216-17, when Henry III, the son of King John, ruled England, the Parliament confirmed Magna Carta. In 1297, Edward I modified it a bit and confirmed it. It was buttressed in 1628 by the Petition of Rights. In 1969, the Bill of Rights formed platform for parliamentary supremacy over the Crown. In other states also some declarations and constitutional instruments gave way to fundamental rights of human beings. In 1976, the United States of America made the Declaration of Independence of theirs. In the same sequence of the development of human rights, the Virginia Bill of Rights, 1776, the Constitution of the United States of 1787 with subsequent amendments of 1789, 1865, 1869 and 1919 paved the higher steps of human rights. The French Declaration of the Rights of Man of 1789 proved to be the landmark in the history of human rights. It led other European countries to include the provisions for the protection of human rights in their laws. In the beginning of the 19th century, most of the states recognized the fact that human beings possess certain rights to develop their personalities. In 1919, the British Parliament passed the Government of India Act, 1919, by which certain local self-government laws were enforced where the First World War had begun. In 1935, another Government of India Act, 1935, was enacted by the British Parliament to appease the Indian people by giving them certain better self-government rights and to have the feet of democracy in the country when there were symptoms of blasting the Second World War. During this war, shocking crimes were committed by the Nazi leaders of Germany, wherein there had been a total suppression of fundamental human rights. There had been established a regime of total lawlessness and tyranny, and the state was rightly called as the totalitarian state. Under the leadership of Mussolini, Italy also followed the pattern of Germany, and Japan also shook hands with Germany. The dictators barbarously neglected human values and dignity within the territories occupied by them. It was at the claim of the Second World War that the Allied nations felt the unavoidable need for restoration of freedoms and rights to the people, which was the most essential requirement for the establishment of international peace and security. On 6 January 1941, President D. Roosevelt made a proclamation of 4 freedoms, that is the freedom of speech, freedom of religion, freedom from want and freedom from fear. He declared that freedom means the supremacy of human rights everywhere. Our support goes to those who struggle to gain these rights or keep them. A number of conferences were held to establish a powerful united world organization where the World War II was in progress. In different conferences, declarations were made adopting the importance of human rights. President Roosevelt of the United States of America and Prime Minister Winston Churchill of the United Kingdom of Great Britain had issued a joint declaration on 14 August 1914, which is known as the Atlantic Charter, which proclaimed that the protection of human rights in all countries was one of the aims and objects to be obtained from victory over the Axis countries. Dumbarton Oak's proposals were in reference to the promotion of human rights as one of the activities of the proposed General Assembly, and under its authority, the Economic and Social Council was also conceived. In the Charter of the United Nations, it has been declared in its preamble, "We the peoples of the United Nations determine to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind, and to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women and of nations large and small, and to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained, and to promote social progress and better standards of life and larger freedom." In Article 1B, one of the purposes of the United Nations has been declared to achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character, and in promoting and encouraging respect for human rights and for fundamental freedoms for all, without distinction as to race, sex, language, or religion. In Article 54-C, it has been said that the United Nations shall promote universal respect for and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion. Article 62 authorizes the Economic and Social Council to make recommendations for the purposes of promoting respect for and observance of human rights, and such other commissions as may be required for the performance of its functions. Article 76-C declares that one of the basic objectives of the trusteeship system is to encourage respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion, and to encourage recognition of the interdependence of the people of the world. Position of human rights under Indian Constitution. Part 2 of the Constitution guarantees certain fundamental rights which are protected by and enforceable at the courts of law, the Supreme Court specifically under Article 32 and the High Courts generally under Article 226, and by other courts and tribunals through reference to the High Court. The human rights as recognized by international covenants may be categorized as I. The right to life, liberty and security of person. 2. Abolition of slavery and enslaving practices. 3. Protection against torture and other forms of cruel, inhuman, or atrocious acts. 4. Abolition of forced or compulsory labor. Protection against arbitrary arrest and detention. 6. Human rights in the process of justice. 7. Right to leave the country and to return to it. 8. Right to own property. This right has been repealed. 9. Freedom of thought, conscience, and religion or belief. Freedom of opinion and expression. 11. Freedom of association, and 12. Right to take part in the governance of the country. The fundamental rights under the Constitution of India resemble in most of the characters of the human rights as declared in the UN Charter and the Universal Declaration of Human Rights. The fundamental rights guaranteed under the Constitution are the following. 1. Equality before law. Article 14. 2. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Article 15. 3. Equality of opportunity in matters of public employment. Article 16. 4. Abolition of untouchability. Article 17. 5. Abolition of titles. Article 18. 6. Protection of certain rights of regarding freedom of speech. Article 10. 7. Protection in respect of conviction for offences. Article 20. 8. Protection of life and personal liberty. Article 21. 9. Protection against arrest and detention in certain cases. Article 22. 10. Prohibition of traffic in human beings and forced labor. Article 23. 11. Prohibition of employment of children in factories, etc. Article 24. 12. Freedom of conscience and free profession, practice and propagation of religion. Article 25. 13. Freedom to manage religious affairs. Article 26. 14. Freedom as to payment of taxes for promotion of any particular religion. Article 27. 15. Freedom as to attendance of religion's instruction or religion's worship in certain educational institutions. Article 28. 16. Protection of interests of minorities. Article 29. 17. Right of minorities to establish and administer educational institutions. Article 30. 18. Right to constitutional remedies. Article 32. These rights, however, are not absolute and exclusive but are subject to certain restrictions. Besides, some of these rights are apt to disintegrate the nation. There are rights enumerated under item numbers 12 to 17 above. Nation is the savior of human rights, and the rights which are apt to disintegrate the nation itself and disrupt the society and its peace and tranquility cannot and should not be counted as human rights. Right of self-determination also under international covenants cannot be adopted as a human right. The great powers and organizations like NATO are often indulged in victimizing and interfering in the domestic affairs of developing of small countries under the prevention of saving human rights. Certain minorities which themselves are involved in atrocities against other classes the country. After enforcement of the Constitution, the Indian Parliament and state legislatures have passed several acts for protection of human rights. Example, Suppression of Immoral Traffic in Women and Girls Act, 1954, Juvenile Justice Act, 1986, various labor acts, etc. Lastly, the Indian Parliament has enacted the Human Rights Protection Act, 1993, and has also established a National Human Rights Commission at New Delhi.